Yes, now it's unmuted. I think that the system now is working, and we are back here for this June seminar at the University of Ferrara, at the Department of. Very happy for a number of reasons. For first of all, to have the opportunity to go back and discussing about digital taxation, which is a tremendously, I would say, I was about to say hot topic, but considering the weather outside, I prefer not to say hot. Let's say important, relevant topic for Italy, for Europe, but actually the more important reason why I'm so happy is that I have a friend of mine here, colleague, esteemed colleague, but first of all, friend of mine, Yan Xu, Professor Yan Xu from the University of New South Wales, Department of Economics or Law. I forgot the department. Business. So my great.
I'm a law person.
Yes, a law person. Yeah, background. Yan's background is law, of course, but the department is business. Not that important, but just to acknowledge the university and the department. Yan is super active in the field of taxation in general, international taxation in particular, but more recently, she has been working on digital taxation from an Australian, Chinese, international perspective. So to say, different views. And in my perspective, this is of paramount importance because most of the literature we are familiar with here in Italy, but also in other universities around us, it's a European literature.
Yeah.
So when Europeans talk about digital taxation, well, they have not all of them, but some of them have a sort of a bias in the sense that this is something that we must do because Americans are making too much money. This is something that we have to introduce in order to get a slice of the cake, so to say, that otherwise would be eaten only beyond the ocean, so to say. And in this respect, as you know very well, you have discussed it, the European Commission has been working on digital taxes, digital taxation ever since 2008, more or less, years ago. And what is the state of the art in I'm about to leave you the floor in a second about the state of the art. We have been doing a lot in the field of VAT. So VAT is one side of the story. But for what concerns direct taxes or other kind of taxes, because digital taxes are not entirely income taxes, well, a lot has to be done. And that's why for us here in Ferrara, but I believe for all the people that are attending both in presence and online, this event is very important to see how the others are dealing with digital taxation, what is the international view in the matter, if there are solutions, and if yes, what would be the best one for European Union. I just stop here. I give you the floor. We have more or less feel free to use the time, half an hour, 40 minutes, whatever you want. Then we will leave some floor for the people here in the classroom or the people attending this event from home. Of course, this is formally speaking, this is an event in the framework of the PhD in European law and national legal system that is operated here at the Department of Law of the University of Ferrara. I stop here. There is a PowerPoint, by the way. Point is available online in the website that I've created for this event. But if you are attending this event online, you know where to find the PowerPoint because it was on the same page you had to use to register for this event. So you cannot miss it. But in any case, I think that the young want to share it right now during your presentation.
Was sharing?
Absolutely. Maybe of some help in this respect. So really, this time is real. Floor is yours, Jan.
Okay, yeah, thank you very much. Firstly, I would like to thank Marco for the opportunity to present at the Ferrara. It really has been more than a decade. I just can't believe this. It has been more than 10 years since I last visited this beautiful university and the lovely town. I'm truly excited to be back. Talk about digital services taxes, so briefly DSTs, and their implications for developing countries. So I'm looking at this topic from a developing country's perspective. This research is co-authored with Michael Wopo. I think probably many of you know Michael, who is a colleague from the same school. The project is still a work in progress. We hope to develop a paper as more data becomes available. The project was prompted actually by invitation to present at a conference on tax and justice. The conference organizers and also tax scholars from Australia asked us whether DSPs can contribute to making tax systems fairer both domestically and internationally. They also raised the question of whether DSTs might be a better solution or a more effective means for developing countries. Probably, I think in this regard, for developed countries as well, to tax multinational companies in the digitalized economy. Our preliminary response was that a DST levied on the supply of digital services. So basically, the tax targets digital services only, and share a similar tax base with the cross-border supply of services, which in recent times has been subject to VAT or GST. In Australia, we call it GST, but they are the same thing. VAT and GST are the same thing. Challenges and issues, raising doubts about whether current reforms can truly address the inequality in the allocation of taxing rights between developed and the developing countries, or bridge the chasm that divides them. Basically, this outlines the idea of our research project. I will now go into details of the discussion. The best final global economy. Many digital businesses generate substantial profits in jurisdictions where they have users or customers, but no physical presence. For example, the market here in Italy, the market in Spain, the market in the UK, etc. And this has frustrated those jurisdictions. Why? Because they are unable to tax such profits, a huge amount of profits. They are unable to tax these profits under existing international tax rules. Well, the final report recommended some long-term solutions. In the short term, jurisdictions began introducing DSTs and other unilateral measures. The DST concept was originally proposed, as Marco just mentioned, by the European Commission in 2018. The proposal targeted 3 types of transactions, that is online advertising, intermediation, platform and services, and the transformation of user data. It proposed a 3% tax on gross revenue derived by large tech companies from these services. France, as everybody knows, became the first country to implement a DST, followed by others such as Italy, Spain, and Nigeria. And similar taxes like the equalization levy in India have also been implemented or proposed around that time. Our preliminary research indicates that about, here is the list, I'm not sure, and we have updated this list of countries that have enacted or proposed a DST or similar measure. Our research indicates that about 3,000 countries, so around 36 to 40 countries, have implemented or proposed a DST or a similar measure. While others have suspended their plans. So, for example, Italy, although Italy has proposed a DST, perhaps not Italy, sorry, Israel, and maybe there is already a kind of law enacted for the DST, but Israel has suspended their DST plan. As DSTs mainly target large tech companies, many of which are US companies. Of course, the US was concerned and launched investigations into various DSTs. These investigations concluded that DSTs violated trade agreements with the US, prompting the US to threaten retaliatory tariffs. However, these tariffs have been suspended pending Pillar 1 negotiations. All involved countries at the time entered into the so-called standstill agreements with the US. And as a result, actually, none of these retaliatory tariffs ever came into effect. Although many countries with existing DSTs continue to collect the revenue for now, they have promised to offset the amounts collected against the taxes under Pillar 1, Amount A, once it becomes effective. But probably everybody understands that won't become true, won't become effective.
Apparently not. I understand that the Pillar 1 proposal has been put on hold at best.
Yeah.
Put on hold at best.
Exactly. And here are just some examples of DSTs and similar measures. We have compiled a list of countries that have enacted or proposed a DST, as I just mentioned, along with some key design details for each. Well, the basic structure of DSTs shares some common features. I will talk about these common features in a second. And the specific design elements vary significantly across jurisdictions. The task force, if you still remember the so-called BEPS 1.0, when the BEPS project was launched, the OECD established a task force. And the task force analyzed the option of a new net basis taxation concept. Basically, the OECD wanted to have a net basis taxation tax to apply to digital services. So the task force analyzed the option of creating a new net basis taxation concept, and that is significant economic presence, which parallels the traditional physical presence concept. Since then, some countries have implemented net basis significant economic presence rules with many practical challenges, while others have adopted SEP, significant economic presence rules that function like actually unilateral DSTs. While the SEP, significant economic presence concept, has been supported, not very surprisingly, by developing countries, it was ultimately rejected by the OECD inclusive framework, dominated by developed countries. The OECD inclusive framework favored a unified approach that led to the two-pillar solution. Notable examples of significant economic presence-based taxation include regimes implemented in India, Colombia, and Nigeria, and more recently, Kenya enacted a SEP regime. Generally, SEP rules rely on very low thresholds, and are often unclear about profit attribution. Actually, this is a very important practical issue. Making them functionally similar to DSTs. So basically, just based on the implementation of real actual SEP regimes, they more or less just like unilateral DSTs. There was not much significant difference between the two. Another relevant development comes from the UN. In brief, a new Article 12B, probably many of you know Article 12B as well. Article 12B was approved by the UN Tax Committee, I think in 2021. The Article 12B would grant limited taxing rights to the source country on payments for certain digital services. As Popular One is now widely acknowledged, it has fallen short of expectations. That is one thing. And another thing is a political barrier to implement Pillar One. Because the likelihood of a multilateral agreement being reached is considered extremely low. So the stalling of Pillar One may signal a resurgence of DSTs. While the design of DSTs varies across jurisdictions, they generally share several common features. So first, DSTs typically apply to various forms of digital supplies, or in some cases, just a single type of supply. For example, online gambling, online streaming, and then online advertising. Their scope is usually narrow, just focusing on digital services. And second, they generally target very large multinational entities that meet specific both global and local revenue or turnover thresholds. And the third, DSTs are usually imposed on gross revenue and a low rate. The diverse designs of DSTs have led to debate about their true nature. So what is actually a DST? What is the nature of the tax? In a recent blog article, Michael Darrow, a prominent tax scholar based in Oxford, Michael argues, based on the UK design, the tax resembles a tariff. Why? Because the tax applies to revenues earned in the UK by non-resident technology companies and targets specific digital services. So he concludes, very interestingly, if it looks like a DST, if it looks like a duck, swims like a duck, and quacks like a duck, and then it probably is a duck, right? Another perspective comes from Wei Cui. I think probably many of you know Wei Cui as well. He's a tax scholar based in Canada. Wei contends that DSTs can be considered taxes on location-specific rent, and digital platforms generate this rent by offering services to users at below marginal cost on one side, while making up for that loss by charging users on the other side. So for example, like Airbnb or Uber, they may provide, for example, users, just like passengers, can use Uber services at the below marginal cost, especially at the beginning stage of Uber coming to the market. And at the same time, Uber can charge a relatively higher price on the other side of the user of the platform, that is drivers or whatever.
So where does the money of Uber comes from? From the driver, or
maybe Uber is not a good example?
Whatever.
But basically that's the idea proposed in the article written by Wei. And he also argues such economic rent can also be generated in just one-sided platforms under data exploitation. For example, Google, and we can use Google services for free of charge right now. But actually, at the same time, when you are using Google services, Google can get user data information that they can commercialize the user data and then make money from that.
That's interesting because, Valentina Passadori is finalizing her PhD thesis on digital platforms.
Yeah.
So she's investigating also, yes, these aspects. And yes, indeed, it's relevant. So they are making money through the services, but selling your data,
Exactly.
information.
Yeah, to leverage.
Profiling maybe the client.
Yeah, like for example, selling user data to advertising company. Or to other kinds of companies. Those companies can use your data to make money, to just target the relevant customers in order to
profiling you
generate business.
I got it.
Yeah, and so that's his argument. Initially, before reading Wei's papers, I wasn't really persuaded by his argument, but after reading the paper, I would recommend. Sorry,
Valentina.
Yeah, Valentina, you can just read his publication, especially the one published in the tax law review, and that was a very, very thoroughly written paper. And you can have a critical view of his arguments, but still, I think it's good to have a broader understanding of DSTs. And also, Wei argues, since the deployment of a technology is non-rival. So, for example, once I deploy my service, Google search engine service to a country, everybody can just subscribe to Google and they can use it. That means the service is not rival. It's not exclusive, not like private property. For example, my computer is rival because if I use it, the other people couldn't use it, right? But Google service and many other similar services are not exclusive. And the deployment of technology is non-rival. Any rent earned from the deployment in a given country, for example, in Italy, can be attributed to that country. So that's his basic idea. And the DSTs allow the rent to be captured by the countries in which such rent arises. In Italy's case, and if the rent arises in Italy, of course, Italy should have the right to tax revenues generated from this location-specific rent. So this also he argues because DSTs arguably aim to enable the taxation of location-specific rent, and because the rent can arise in either consumer or producer jurisdictions, the taxes should not be regarded as destination-based. What does this mean? This means DSTs can be distinguished from VATs or GSTs, because VATs and GSTs are destination-based indirect taxes. And finally, there is another view that is from African Tax Administration Forum. And the forum argues that DSTs can help collect taxes from highly digitalized businesses that pay little or no taxes in Africa. And the forum has proposed a kind of a suggested approach to African countries. And under their suggested approach, the DST is not designed to be an income tax. Instead, it's levied on the supply of narrowly defined digital services at a fixed rate, based on gross revenue derived from or attributed to users located in the taxing country. So what does this mean? It's not designed to be an income tax. That is a very, very interesting point. Basically, that means because the tax is not based on net profit, it's not designed as an income tax, it's not creditable against income tax. And for double taxation agreement purposes, this is important. DTA, if DTA applies, we know DTA provisions prevail over domestic provisions. And if a tax is a covered tax on DSTs, and then the relevant residence country should provide tax credits, right? So, but because the DST is not designed to be income tax, to be as an income tax, so for double taxation agreement purposes, the tax can be introduced unilaterally. That's the point. Yeah, I don't need your agreement to implement a DST. If it's covered, and then it requires negotiation, right?
Sure.
Because that affects the other countries' taxing rights. So very, very interesting development. Meanwhile, don't forget VAT. This VAT is gaining traction over the past several years. Now VAT has now around 100 countries have implemented implemented rules to target the cross-border supply of digital services. So there are quite a number of things happening at the same time. All of them target almost the same object. In order to understand more about DSTs, we have selected 4 countries as case studies, each representing one of the 4 World Bank income classifications. So that is a high income, upper middle income, lower middle income, and low income. And the UK, yeah, of course, represents a high income country. Its DST took effect in 2000 as a 2% tax on the revenue of certain search engines and social media platforms and online marketplaces. A key feature of the UK DST is that the tax is based on the location of the targeted audience of the digital services users. So basically the users, for example, advertising users of the advertising services, private individuals like you and me. Revenue is subject to tax as long as the services are targeted at UK consumers, even if the purchaser is outside of the UK. So this is a very, very important feature of the UK DST. The UK DST targets the users of the relevant digital services. If the users are in the UK, and then the UK has the taxing right of the relevant revenue.
Okay. So let me give an example. For instance, there is a Canadian company making use of a British based advertisement system to sell product to the British consumers.
Yeah.
So in this scenario, the people looking at the advertisement or whatever are in the UK.
Yeah.
Platform is the UK, but the company asking for promotion
Sure, yeah, it's in Canada.
Nonetheless, the tax is charged.
Yeah.
Okay.
So yeah, this will distinguish the UK DST from another DST I will talk about in a second. So countries can have a different design based on their own economic interests and their economic reality. If I have a large consumer market, of course, I want to target consumers. If the payment is from my country, of course, I will target the purchasers, the payment flow, right? So different approaches to DSTs. So yeah, again, this makes the UK DST a user-based digital tax. One justification for DSTs actually is the concept of user value creation. Because the value created in a specific jurisdiction can be earned only in that jurisdiction, DSTs reflect the value creation. So yeah, somehow the UK approach here is justifiable based on the user value creation concept. Colombia is classified as an upper middle income country. It enacted a significant economic presence rule in 2022 as a nexus for income tax liability for non-resident entities. Under the rule, a non-resident taxpayer is deemed to have a taxable presence in Colombia if they meet the revenue threshold of around $340,000 US dollars. Apparently, this threshold is quite low. Yeah, and either the user-based threshold or the digital presence based threshold for both. The tax applies to digital services. Unlike India's significant economic presence rule, Colombia's rule imposes a tax on a gross basis, making it akin like DSTs. India is a very interesting country.
Sorry to interrupt. Sorry, yeah, anyone, but there was a question from the floor regarding slide 7. But we are, can we regard DST as an excise tax in the sense that it is related to sales of a specific service?
Yeah, I think yeah, it is
a flashback. Yeah,
that's very good.
We have already addressed it.
Yeah.
From the dimmer. Okay. Sorry for interrupting.
No, not at all. Yeah. Please jump in.
Yeah.
Just
I'm doing that.
or questions.
I'm doing that.
If you have any comments or questions, please just jump in. Yeah, and India now we come to India. India has a very complicated tax system, as many of you know. And India is also classified as a lower middle income country. It was the first country to impose a direct tax on digital services through the so-called equalization levy in 2016. And the levy applied originally only to online advertising at 6%, but it was expanded in 2020 to include e-commerce and platform providers at 2%. Around that time, India also introduced a significant economic presence rule in its income tax law in 2018. A taxable presence is created if either the revenue threshold or the user threshold is met. So basically, for example, even in the US, as we know, the US doesn't have a federal level VAT. However, at the state level, VAT is applied just like VAT is applied in European countries. And then also with the very significant Supreme Court judgment that is with their case in the US, and the states have started to implement or use an economic presence nexus to target across intro-state supply of digital services and digital goods. And they target the state level sales taxes. They are applied also based on either the transaction threshold, revenue threshold, or the user threshold. So for example, if the revenue turnover threshold, they can set up the revenue threshold at, for example, $300,000 a year. And then they can also set up at the same time a user threshold, let's say 100,000 users based in this state. And this is the same with the Indian significant economic presence regime. And the SEP income is deemed to accrue or arise in India to the extent is attributable to the transactions or activities constituting a business connection with India. Such income is subject to the standard corporate rate of 40%.
40%.
Yeah,
40.
which is really, really high. Yeah, internationally and comparatively, it's very high. In Australia, the standard corporate rate is 30%, which is also quite high.
Here is 24, so.
Yeah, not too very high compared with India.
Sure, of course.
Yeah.
Nearly half.
Yeah, so it's really, really high. And due to the low revenue threshold and very unclear attribution rules, the Indian SEP regime has created many uncertainties, of course, for foreign businesses in India. So foreign businesses complain a lot in India. And notably, unlike the UK DST, India's education equalization levy on advertising was imposed on payments from India for such services as to whether the taxing country is the source of payments to the platform company. The Indian equalization levy can therefore be viewed as a payment-based tax targeting large tax companies. So basically, under the Indian equalization levy, as long as the payments are flowing from India, and then India has the taxing right. So you can say this is different from the UK and DST.
Yeah.
With the SEP regime in place, India abolished both the general 2% equalization levy and the 6% equalization levy on advertising in these recent 2 years. And then Rwanda is the only low-income country in our case, in our list of countries which have enacted or proposed a DST. As the decision was just very, very recently made by government, limited information is available about their DST proposal. However, the scope, based on the limited information we have got recent so far, their scope appears similar to that of many other DSTs, and the tax is expected to apply to platform revenues from digital services, search and subscription and services, etc.
But then I think that for countries like these, with all due respect, of course, the most challenging part is to really to make the tax workable in the sense that you need efficient, super efficient tax administration, people in charge that know how to handle these kind of charges or fees, and most than that, the capacity, the technical infrastructure to understand where the consumer is using the IP, that kind of.
So administrative capacity is a huge issue in developing countries, especially poor developing countries. So next we look at how do DSTs compare with other similar taxes. We firstly look at Pillar 1, which along with Pillar 2 was developed to modernize international tax rules in response to globalization and the new digital revenue models. Pillar 1 Amount A introduces new international taxing rights, shifting the rights to the so-called market jurisdictions, where revenue is generated rather than where a business has a physical presence. And the multilateral convention on Amount A requires countries to reallocate a portion of profits above a specific threshold to market jurisdictions and remove DSTs or similar measures at the same time. Pillar 1 applies only to the largest and the most profitable multinational companies, as the thresholds are very high, as you can see from this slide. Global revenue of 20 billion euros, with at least 1 billion euros allocated to the market jurisdiction, and profitability exceeding 10%. So there have been some calculations. Basically, these studies find less than 100 companies meet these thresholds. So in terms of administrability, it's not difficult to target these very large companies. And about 2/3 of these companies are US companies. Amount A doesn't ring-fence the digital economy, but applies more broadly to both digital and non-digital multinationals. Well, not explicitly stated, the Amount A reallocation is essentially a formulary apportionment, primarily focused on sales within a jurisdiction. I'm not sure if you know formulary apportionment. It is a profit allocation rule, which is different from the traditional arm's length standard or principle. And it uses a formula to allocate revenues between related parties within a corporate group. So Amount A doesn't use the traditional transfer pricing methods to allocate revenues, rather they just use a formulary apportionment. And then another relevant tax concerns Article 12B on automated digital services under the UN Model Tax Convention. As just mentioned earlier, the UN Tax Committee approved the inclusion of this new article. The definition of automated digital services, as shown in this slide, emphasizes that such services require minimal human involvement. Once you deploy a technology like Google search, and there was no need to have human beings involved in the search service process. Consistent with Article 12 on royalties, Article 12A on fees for technical services, Article 12B provides a maximum withholding tax on gross payments for automated digital services. But the service providers can opt for net basis taxation, which is charged at the ordinary corporate tax rate on an amount of deemed qualified profits. How to determine the deemed qualified profits? The process is quite complicated, so I will just skip that. if no information on deemed profits is available, and then gross basis taxation applies. So somehow Article 12b provides a kind of flexibility for countries who choose to use to adopt this article. Article 12b has several features that distinguish it from DSTs and Amount A. So first, it solely relies on the location of the payer as the nexus between the market jurisdiction and the digital services. Second, Article 12b doesn't include any revenue threshold as long as there is a payment on digital services is from my country. Yeah, the source country can impose a withholding tax on that payment. And the third, the net taxation option uses a modified deemed profits method to attribute net profits to the taxable nexus. And then, yeah, at the moment, Article 12b, probably as many of you know, has not yet been incorporated into any double taxation agreement. So basically, it's just a proposal under the UK, under the UN tax model convention. The UN tax committee aims to create a fast track instrument to streamline the process of adopting this new provision in existing treaties, although outcomes of this instrument remain to be seen.
Actually, what is the situation in Australia? We are familiar, of course, with Article 12b here in Italy.
Yeah.
But Jan, to be honest with you, the reaction by the academia, by the stakeholder, has been somehow cold, hesitant. Yes, we know there is interesting. It's a good proposal, but there was no relevant engagement on that by the government, the tax administration. It was like kind of set aside.
Yeah.
What is that? Is like that in Australia? Or?
The same. Yeah, the same. Yeah, and you probably know this well as well. Australia is probably the loyalist country to the US in the world, I would say. The US is not happy with DSTs, not happy with relevant similar measures, including Article 12b and then significant economic presence. So of course, Australia wouldn't do anything about this. And there was no any discussion about Article 12b in Australia, basically. Yeah, full stop. And with regard to DSTs, as you can see from the slides, actually New Zealand, our neighbor, has already proposed a bill on DST. How about Australia? Nothing. Australia says we will participate in the OECD two-pillar solution. We would prefer a unified approach rather than a piecemeal unilateral measures. Again, the underlying reason is the US is not happy with Pillar 1 and not happy with DST.
So Australia is very careful. Let's say careful in the matter.
Yeah, yeah, quite. Yeah, I think that is quite the case in Australia. Yeah.
Oh.
And yeah, that's it. Yeah, VAT and VAT. Finally, VAT. VAT should consider in this discussion as well, because this indirect tax is also targeting supplies of goods and services, including cross-border digital services. VAT, as we know, operates on the destination principle to ensure it is levied only in the jurisdiction where final consumption takes place. However, applying this principle to digital supplies where no physical property crosses borders is a bigger challenge, right? So it can be very challenging. One major challenge is tax collection, how to collect the tax from private users, basically. From business users, that shouldn't be a problem. Because the destination country usually like the means to collect VAT from foreign suppliers, when foreign suppliers are not physically present in the country. The tax might be collected from domestic consumers registered for VAT purposes, particularly, basically, this refers to business VAT users, consumers. Collecting VAT becomes difficult when the consumer is a private or final customer, persons like you, me, and anyone in their private life. Several models have been developed to address the issue. One approach is the foreign vendor registration mechanism, and the other is to require online marketplaces or digital platforms to collect VAT on business to consumer digital supplies. In this regard, Australia has been the forefront runner of introducing these models. Foreign vendor registration mechanism was introduced in Australia in 2017. And then I think in 2019 or 2018, the government introduced legislation on market platform and collection, reporting, etc. Yeah. And I think the UK also has modernized your directives to post these collection mechanisms within European member states. Well, these both models have become increasingly common. They have not been effectively implemented in developing countries, especially underdeveloped countries, due to administrative, technical, and other constraints. So, for example, as far as I know, China is a developing country. It's not very poor. It's not really a low-income country.
It's a bit of a funny to call it China developing country, you know?
It's precisely, I would call China an upper middle income country. Upper middle income. It's not really a highly
upper middle.
Yeah.
How many upper?
Yes,
Sure.
the eastern
joking.
places, they are very advanced.
Yeah.
As you just mentioned this morning. In western parts, northern parts of the country, people's living standards are still relatively low. And then implementing these collection models, foreign vendor registration or platform collection shouldn't technically be a problem in the country, but in terms of regulatory regulation, it's not very easy to implement these two regimes. Why? The reason is very simple. China has a foreign currency control system. So they have a regulation over foreign currency. And if you use these mechanisms to collect the taxes, that means the government wouldn't be very effectively applying their foreign currency control, because payments can be just directly collected. And if the payments are huge, and then how to control the foreign currency flow.
So you say that the reason why it's difficult or impossible to buy online from China is that
you can buy online, but up to a limit. There is a certain threshold.
Okay.
Yeah, and of course the government wants people to consume. Yeah, the government encourage the consumption, but they also have the same time regulation on foreign currency. It seems every day final consumers or just private individuals can have foreign transactions up to like 50,000 renminbi. And you needed to convert that to
anyway, it would be like maybe some €1,000 anyway.
Yeah, there is a cap. Just basically, you still can purchase online from other countries, but there is a limit. Yeah, that's
I understand.
Yeah.
And Hong Kong, of course, is not like that anymore. Yeah.
No, you mean Hong Kong?
Yeah, Hong Kong, there is no
any currency control. Yeah.
Yeah.
I'm still
different currency, different system.
Exactly. I'm still optimistic about Hong Kong.
Okay.
Although there are many negative comments.
Yeah, because they still use, of course, the Hong Kong dollar, which is completely on the market.
Yeah, for tax purposes, Hong Kong is completely separate from the mainland of China. It has its own currency. It has its own fiscal system. It has its own tax system. It has its own DST network. Okay. So totally
detached.
Yeah, separate, exactly. And all the revenues from tax collection in Hong Kong
stays
are used only for Hong Kong.
Okay.
Yeah, for Hong Kong only. So totally, completely separate regimes. That is why in taxation we call it one country, two tax systems.
Yeah.
Okay, now as can be seen, DSTs may overlap with VAT in terms of scope as both apply to digital services. However, the scope of DSTs is much narrower than that of VAT. Some digital services, such as streaming services, have virtually just private consumers, ordinary individuals. We would use streaming to get like YouTube music or Netflix movies, things like that. In such a case, a DST and a VAT may apply simultaneously, and both are paid by the supplier. Does this constitute double taxation? Or does it just feel like a double taxation? Yeah, we asked this question. We know VAT is a consumption tax, it's an indirect tax, and the intermediate businesses act as tax collectors, they're tax agents, basically. And the actual burden falls on private consumers. In contrast, DSTs are designed to target the businesses themselves. Well, the DST, whether DST costs can be passed on to consumers depends on many factors, such as marginal costs, market demand, and the competitive dynamics. So in terms of the tax incidence of DSTs, probably, the burden, the incidence is not very certain, but it's very certain for VAT. The final burden is on private consumers, not on intermediate businesses. For digital services that are primarily provided for business consumption, there was no double taxation because the VAT is generally recoverable and does not stick with the businesses. And then the next question we ask is, compared to other approaches to digital taxation, could the DSTs be a better solution, particularly from the perspective of developing countries? And this is also relevant to developed countries as well. There are several potential benefits of DSTs, and one is that they target some of the more valuable businesses in today's economy. In the modern digital era, tech-driven business activities often surpass traditional sectors like tourism here in Italy or agriculture, and in some European countries, maybe Spain.
Could be.
Yeah, agriculture products in Spain are actually
Quite important.
quite nice. So this and we want and because of this, so probably that means for many developing countries and also developed countries, and the digital sector may soon become their most valuable single economic activity. Another benefit is that DSTs are relatively easy to administer. This is a huge benefit or advantage, especially for developing countries. With just fewer taxpayers and relatively simple calculation and lower rates, DSTs can be more manageable for tax authorities in developing countries, especially when compared to more complex frameworks like Pillar 1 Amount A. This morning, I just went through the simple fact sheet of Pillar 1 Amount A again in order to familiar myself with their rule. Must say it's hugely huge.
This is not law anymore, perhaps not even taxation anymore.
Yeah, it's just beyond ordinary human beings understanding. I think it's somehow deliberately made it so complicated.
This is opinion that I heard a lot of time all around the world.
Yeah.
Start thinking that this is not a cliche, or call it as you like, prejudice, call it as you like, but several academics all around the world share the opinion that all those rules have been introduced only by Big Four consultants to make even more money. As simple as direct at that.
Exactly.
And the more I talk about that, like everywhere, again, in Australia, in the UK, in Germany, I traveled a lot in the last month, and wherever I go, the feeling, the sensation, the vibe that people say is that, well, probably these rules are impossible to understand. None of us in the academia has the time, the will, maybe also the brain to dive into that. And our understanding is that only the big consultancy company have the human workforce to deal with that.
Yeah, they have the human and also financial resources
And
to provide the services.
And of course, good point.
Great, right?
Good point. Both.
Yeah. And so anyway, that's pillar one. And I'm working on another paper on pillar two. Pillar two is also difficult.
It is Alessandro Casanova's subject of peace.
And pillar two also has a lot of issues. But anyway, because this topic is not directly relevant to pillar two, or just skip pillar two. But I really wanted to make a comment. I spent really a substantial amount of my time to just understand their flow chart, the 5 steps pillar two, right? Cover the taxes and the eligible exclusions. And yes, quite a number of rules.
Carve out, effective tax rate.
Carve outs. And also the ring-fencing rule about whether a country can collect pillar two minimum tax first and refund them later. No way, according to the OECD. But then other academics challenge it. No, the OECD is wrong. You can't not just simply say you cannot do that because you don't have really provide reasonable justifications for denying countries right to whatever implement their domestic measures.
Absolutely.
But anyways, it has created a lot of controversies. Basically, and I don't think pillar two is a good solution.
Me neither. But I've never met a person up until now that said it could be a good solution. But the only exception of the people working at the university.
They wanted this to continue.
Exactly, nobody but them.
And I will come back to that. In a second. That can be a very interesting issue, although I'm not very optimistic. Anyway. So that's another benefit. It's relatively easy to administer especially for developing countries and even for developed countries. I remember one year when I attended this International Fiscal Association annual congress, I met some really prominent tax barristers from the UK. And we talked about the complexity of pillar two. And I said, it is a huge concern for developing countries. And he responded, it is a huge concern for developed countries as well. It's just too complicated for everyone. Basically. So that's the DST benefit is easy to administer. And DSTs also give developing countries the opportunity to tax digital companies with little or no physical presence in their country. There may be additional benefits, especially for developing countries. So, for example, the African Tax Administration Forum argues that taxing digital companies could help boost public confidence and trust in the fairness of their tax system. This in turn may encourage voluntary compliance, which is a hugely critical challenge, especially for many African countries, because compliance rate in these countries is very, very low. On the other hand, the implementation of DSTs raises several concerns. One issue relates to revenue generation. There was just limited information about the impact of DSTs, the impact on especially revenue generation. Among our 4 case studies, we just found the India's equalization levy appears to just generate a very, very small, tiny amount of tax revenue. Even in the UK, a high-income country, according to their data, DST revenue has accounted for just 0.04% to 0.06%. So half of 0.1% of revenue in recent since 2020. Yes, so it's really, really tiny. I can't really say nothing, it's still money, but it's tiny. this suggests revenue gains may be just modest in countries implementing DSTs or similar measures. Another issue is the potential for retaliatory measures by the US. The US may initiate investigations and impose countermeasures such as tariffs. And we have already seen the current government, what the current government is doing. So yeah, if a country insists on implementing a DST, probably the US would retaliate against their measure. Although studies also argue that retaliation is not in the best interest of the US businesses. DSTs may also affect investment in technology and innovation, particularly in countries striving to grow their digital sector, including European countries. And these countries recognized the need to encourage technology development and to become competitive in the digital age. At the moment, we have the US as a leader in the digitalization of the company and also in innovation. And China is a very, very strong competitor as well, is also a leader. How about the EU? The EU has lagged behind, to be honest.
They are not big champions in deal with.
And Australia apparently is behind. So yeah, we need to really come up with the policies to encourage investment in innovation, in digital development. So there are, therefore, is somehow I think it's crucial that the DSTs should be designed in a way that aligns with broader socio-economic development goals of the relevant countries, rather than just simply focusing on taxing a company, taxing profits here from my user or from the payers from my country.
So we need more carrots and less sticks.
I think probably both. Yeah, you need just to strike a balance, which is difficult, of course. Yeah, of course, it's difficult. Administrative capacity is another persistent challenge. In developing and also developed countries, issues such as taxpayer registration, especially in African countries, and the tax enforcement continue to pose impediments, regardless of how the DSTs are applied, are implemented. A further criticism of DST is that they are based on gross revenue or turnover. So what does this mean? What does this mean? This means the taxes can be imposed even when a company is in a loss position or operates with very, very low profit margins. However, this view has been refused in studies. And the relevant studies argued that many digital companies operate with very, very low or negligible marginal costs. Once a platform is running, each additional transaction is just largely automated, right? As a result, revenue closely approximates the platform company's marginal profits, making a tax on revenue similar to tax on marginal profits. So yeah, it's not a huge issue. Even in cases where marginal costs are not zero, that means we shouldn't ignore the marginal costs. Still, this issue can be mitigated through the minimum threshold and the lower tax rates. So basically, this issue can be overcome. It's just a technical issue. So yeah, I think I'm running out of time. I need to finish. Yeah, soon.
No worries. Yeah, but we are. Yeah.
Okay.
The conclusion.
Yeah.
Okay.
Yeah. Finally, what conclusions can we reach? I think one thing is clear. And that is DSTs can serve as a legislative tool for countries to tax highly digitalized businesses. And this is especially relevant given that among A, the OECD preferred unified approach or solution is very unlikely to come into effect. Its implementation is conditional. It depends on what? It depends on whether jurisdictions that host the headquarters of at least 60% of in-scope companies ratify the Amount A agreement. As we just mentioned, over 60% of these companies are US companies. Of course, the US wouldn't ratify the Amount A agreement.
Deadlock scenario.
Exactly. However, a field Amount A appear agreement and a resurgence of DSTs will not really make the challenges of taxing the digitalized economy go away. The challenges are still there. Moreover, Amount A, Article 12B, DST, and significant economic presence and the VAT, all these relevant measures do not seem to address a core, in my view, a core economic policy issue, that is the promotion of technological development. We really need to develop advanced technologies and deploy these advanced technologies in every corner of the globe, of the world, to developing countries and also to developed countries.
We have to disseminate in to everywhere.
In a more equitable way, in a way. And the fact that most affected companies under these measures are US companies, I think illustrates something. This fact implies the success. We must recognize this, the success of the US in encouraging innovation and growth. To make this success happen in other countries, particularly in developing countries, more probably needs to be done than taxation or reallocation of taxing rights, because this fundamental economic issue cannot be solved by tax measures, right?
Exactly.
So from a tax justice perspective, for the failure of Amount A, the US rejection of Pillar 2 and the potential rise of unilateral DSTs raise serious questions about whether the OECD is the appropriate institution to lead international tax reform regarding the digitalized economy. And the key question remains, can we achieve a more just and equitable international tax framework? Yeah, and then here are some further thoughts, and I think I'm compelled to list these questions here. Without a multilateral agreement brokered by the OECD, or more precisely, without one that includes the US participation, what other options do we have? Yeah, we need to ask ourselves. There is very clearly growing dissatisfaction among developing countries with the outcomes of the OECD led project, which many argue has favored larger, richer countries over smaller and the less developed ones. Most developing countries believe that the UN is a more legitimate organization to lead the global effort to resolve the challenges of taxing the digitalized economy. The proposed UN Framework Convention has received overwhelming support from especially developing countries. Is the UN more likely to achieve a true multinational solution for digital taxation than the OECD? That's the question I wanted to ask here. I think, based on for this research, we have asked more questions than answers we have found. And for that question, I think my tentative answer is, unfortunately, the answer may be uncertain, because many developed countries, including Italy, are skeptical about whether a UN agreement would reflect their interests. So countries always have competing different interests and needs. They want things differently, of course. It's very, very difficult to mitigate the gap between these two broad camps of countries in the world. So I'm quite pessimistic. I can't say a way out. Seriously, I just can't. Yeah. So that's the end with this. I finish my my discussion. Thank you very much for your patience.
No, absolutely. Thank you for your. Okay, we go back to Google Teams. Thank you so much for the presentations, for the idea that you have shared, and also for the views, I would say, about the overall phenomenon. You said you are a bit pessimistic, but you are in a country where you have to be optimistic. We are optimistic by design, because otherwise we would jump out of the window or somewhere.
Yeah.
But indeed, there are differences between regions and countries whose roots are in history,
Exactly.
in economics, in development, in money making sometimes. So, and it's difficult to overtake them. Well, the history of these days teaches us that we actually are living in a fragmented world. If you look at what's happening, not only in Ukraine and Russia, but also in the Middle East, etc., etc. So there are places in the world where you don't see two countries fighting each other, but you see different understanding of international relations are clashing one against the other. And of course, we do taxation, we come at the very end of this story, we come at the very last moment of this conflict, but indeed also taxation is involved into conflict. Our job as academics, I would say, is to pave the road that others are supposed to walk on through. And I can't say that I'm optimistic, but I want to say that I'm optimistic about what the UN is doing.
Yeah.
Because actually, even if, Jan, as you have pointed out, many things, many positions are still on the paper and on the paper only,
Yeah.
still, at least we have a debate, we have a discussion,
Yeah.
we have a circulation of
Yeah.
If I think about myself, think about 10 years ago or 20 years ago, well, yeah, we knew that there were UN tax treaties, but no more than that.
Yeah. Sure.
Today, something is happening, so we have to take time and to perhaps keep on working.
Yeah.
In this aspect.
Indeed. Yeah. I think you're right. We need to remain hopeful.
Mhm.
Historically, human beings have already really thousands of years of history. And I'm sure human beings must have experienced a lot of difficulties, frustrations in the long history. I think basically what I really mean to say is we need to repeat making the same mistakes again. That's the lesson.
That's important. That's important.
Because we keep making the same mistakes over the long history. And actually during the over the past century of the international tax development, there were various instances where a more equitable international tax regime could be somehow introduced, but then later on there are like political influencers or developments that disrupted the process. So now the African countries have taken the lead to make their voice heard by many countries in the world. They want a more equitable international tax regime. So I think, yeah, you're right. We need to remain hopeful and probably work together. We can create something that has never been achieved over the past century. Yeah, hopefully.
And keep optimism and do
And also
good
the
job.
Trump administration, it will not stay there forever.
Exactly.
I'm so sorry, this is
No, it's okay. There were, there was a joke that was attributed, but not attributed. Actually, there are sources about that to Henry Kissinger, the Secretary of State during the Nixon era, when he took his position as a Secretary of State. He said to the newspaper, "We will not make the mistakes that others have made. Period. We shall make our own mistake."
very good comment.
So it was really funny that this way. Yeah, thanks a lot. There are people, of course, attending these events from home. Yeah, If there are questions or comments from home, from your university, from your office, wherever you are at the moment, please turn the mic on or the camera on and feel free to ask, and including the people attending here in this event. Yeah, Alessandro. And then MT later. Sure. You first, then MT.
For example, their institutional system, like I'm seeing in the other common law systems and inferences that we know. But for example, as you mentioned, they are based on the gross profit.
Yeah.
So they take into account the turnover as tax base, if I understand correctly. And in Italy, we had a kind of a little dispute and institutional problem related to the ability to pay principal and the chance to pay an enterprise or a company in a loss situation. Would you have some problem, consider to have the same problem or same issue in Australia as well, considering taking into account the constitutional principle and the chance to tax and to levy a tax upon a taxpayer who is in a loss position, considering the turnover and loss?
Yeah, that's a very good question and also comment. I'm not very familiar with constitutional issues, constitutional law here in Italy, but I'm sure there must be some constitutional issues arising from the implementation of DSTs or other kinds of taxes. In Australia, DST is not an issue at all. However, Australian constitution does limit the state's taxing right over particularly indirect taxes, particularly excess taxes. Italy is a unitary country, isn't it?
Sure.
Yeah. Australia is a federal country, so you have a federal Commonwealth government at the federal level, and then states. In total, 8 states and the territories. And states, the Australian federal system is quite similar to that in the US. And so states do have taxing rights over various kinds of taxes. However, based on the development of the Constitution and the constitutional principles as well as the case law, states are not allowed to impose excess tax. The fundamental reason is that because this would affect intra-community free trade, like in European Union.
Would create distortion.
Yeah, exactly, economic distortion. So what I mean to say is, although we don't have issues with the DSTs, we do have constitutional issues with the implementation of excess taxes. There was a very, very significant case that happened in the previous 2 years. I think in 2023, the state of Victoria, the capital city of Victoria is Melbourne. The state of Victoria enacted a law to impose excess tax on the users or owners of electrical vehicles for their use of road in the state. And when the tax was supposed to be implemented in the state of Victoria, 2 private individuals challenged this imposition. They argued that this tax is unconstitutional. And the case went from the state level to the federal level. And finally, the High Court decision concluded. The High Court is the highest, just like the Supreme Court in the US. The High Court decision said the states didn't have the right to impose tax because this would affect
interstate trade.
But actually, this ruling, in my view, at least to me, I was very disappointed with this ruling because this can be a state level, which is very important and what is needed, state level initiative to address climate change issues. Yeah, because with And on one hand, the governments, including the federal and the state governments, wanted to encourage the uptake of electric vehicles or hybrid vehicles to address net zero transition. The government has already committed to net zero transition in 2015. And then that means that the revenues generated from the traditional excess tax on fuel probably would be going down over time. You need to think about another way to generate revenue. Moreover, in terms of EV road use charge, although EV cars do not generate emissions, they use roads. Roads are public goods as well. Yeah, they would diminish the value of the roads over time. And for that, of course, we needed to impose. So I think in terms of environmental protection and also constitutional or initiative to address climate change issues, the ruling was not very helpful.
Okay.
If the federal government, that means that basically just means if the federal government doesn't do anything about how to address net zero transition, the states basically just can't do anything either. That really basically just blocked the country from developing systems.
Right. The Commerce Clause.
Exactly. Yeah. And I understand that in other countries, constitutional issues can also arise with regard to particular taxes. For example, in Brazil, Brazil also is a federal country. When the government wanted to merge their quite complicated VAT, whatever they call, taxes at the federal and state levels, it sound like a more manageable, simplified regime. And then there was a serious constitutional issue as well. So yeah, I'm sure there must be constitutional issue. If I think a new tax measure could solve a broader economic problem, maybe policy concerns should be given more weight than just technically sticking to the traditional interpretation of the concept, like access tax.
To understand where we want to go.
Yeah, just develop the jurisprudence. Of course, changing constitution in any country can be a huge issue. It takes time. It takes years and years. It's difficult to change constitutional provisions, but the courts can do something.
Yeah.
That's the point.
Very good point.
Yeah.
There was another question from the floor from MT.
Oh, hi, greetings, everyone.
Okay, we can hear you. We cannot see you, but at least we can hear you.
Okay, I'm in the comfort of my. Let me open my camera. My camera is.
You want, but otherwise we.
Oh, it's disabled.
It doesn't matter. Okay.
Okay, cool. Let me show. Firstly, I stand to be corrected, though. I think DST forms part of indirect taxation. Am I correct?
Yeah. Direct tax.
Yeah.
So now looking at the international tax law perspective, I just want to know whether when it's imposed, like the jurisdiction with the taxing right, do they look at if there is any trade agreements between the two jurisdictions, the two countries, or when they impose the tax, they would also look whether it's a developing country or underdeveloped country, or in an international tax law perspective. Because I think I do understand the fact that each and every country have designed their own legislation in terms of how to impose domestically. But now, when it comes to the international perspective, how this will be implemented, or if it's already there, how is it implemented on different jurisdictions? And when it comes to the issue of compliance, the party that does not comply, how would it be easy to impose?
Well, MT is from the University of Zululand in South Africa, by the way, in order to introduce. So I think MT, the question is, how would it be possible for a country to actually collect the tax if the multinational omits or fails to make the payment.
Is that right?
That's correct. Yes, thank you.
It is
Okay, yeah, that makes sense. So in India's under India's approach, it is quite doable because they target on payers. If the payments are from India, and then the government can collect a tax using the withholding mechanism.
okay.
Yeah, so that is simple. And the UK DST case, because they target users, and these multinational companies must. They are bigger companies. Although they are
Yes.
not physically present in the UK, they are there. They wouldn't just disappear overnight.
Okay.
So probably there would be some mechanism that can be implemented by the UK government to require the foreign platform companies to pay tax based on whatever calculation method the UK government uses, and then to pay the tax and remit the tax back. Because apparently, if you collect taxes from the users, it's just administratively too difficult and too costly. You must collect taxes from large companies
Yes.
or large entities.
Which are more compliant by design
Exactly.
than the
exactly.
small one.
Yeah.
Okay. Lastly, Marco, the very last
Oh.
question.
Yeah.
The online purchases, here in South Africa, it's regulated by the Customs Act, where the customs duties are imposed, But
Okay.
now, can we? Is it safe to say, since we are using digital platform when we purchase online from the other jurisdiction, that also falls under DST? Yeah, even though it's regulated by the Customs Act in the perspective of South African perspective. But now, will it be safe to say that it, not because the digital platform is used, it fall under DST? I'm not sure. Thank you. It will be
in Europe, irrespective of the device used to finalize the purchase, platform or non-platform, the goods that you buy or the service that you enjoy online are charged with VAT. So everything falls under the VAT. If the goods are imported, for instance, you go on on Temu and you buy something which is delivered from China. Well, of course, on those goods, VAT is charged upon importation. So, then is a special, let's call it a special kind of VAT for tax purposes. It's a VAT upon importation, but still falls under VAT. Then from a practical perspective in my country, the customs office is supposed to assess whether the payment has been made or not. But irrespective of who is in charge to audit and to check and control, VAT is charged.
Yeah. And in terms of customer duties, if you mean your customer's duties, to impose customer duties on online purchase of goods is not very difficult, because anyway, the physical goods will cross over the customers, and then at that point, the customs authority can collect customers' duties if the relevant goods exceed a certain amount of value prescribed by the relevant country. But for digital services, there's no way to impose customs duties, because the services can be just provided instantaneously online and without the necessity of crossing over a physical control by customers, etc. That's why all the current relevant measures focus on digital services. Because the digital services basically just raise a lot of conceptual and also practical problems.
Absolutely.
Thank you.
And also customs duties. I think the UK, within the EU, you should have already some mechanisms to collect customs duties, and because it seems the UK has already abolished this de minimis
rule of 150.
low valued rules.
Yeah, we have a system involving intermediaries in that as well.
Yeah, and then because Australia did the same thing a couple of years earlier. So every single package shipped from overseas to customers in Australia, and then the relevant VAT or GST will be imposed on that package.
Exactly.
The goods. It's not an issue at all. No.
From a practical perspective, not even here, they say.
Yeah. But again,
Okay.
services are difficult.
Sure. Thanks again, Jan. Thanks everybody for staying with us in such a warm day here in Ferrara. I don't know where you are at the moment, maybe in a much cooler country. I don't know. Well, the seminar is over. Thanks again, and see you next time. To all of you.
Thank you very much.
Bye everyone. Ciao a tutti. Bye.
Bye.
Bye. Thank you.
Bye. Thank you.
Bye.
Thank you.
Yeah, the event. Okay.
It's good to have some audience from Africa.